Alex here with part 46 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over, however, are number one, I'm not in the middle of this right now. I'm completely and totally over. It's closed. My case is completely and totally over. It's closed. And it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the explanation of the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 45 with my filing of the reply, and we're about to go into part 46 now, which deals with the judge's response, which, surprising to me at this time, is for him to set a hearing. And this is surprising to me because I really don't know how this works at the time. And the way that he dealt with the prior three motions, well, I guess he only really dealt with one of them summarily. Two of them I was able to solve by stipulating, and one of them he resolved by mailing me an order that was very favorable to me. So this is the first time I have seen that the court can set a hearing, and I'm going to pick up on this going forward, but I don't suppose there is any reason to go into my mindset because for the most part, it's going to be the same as what it was in part 45. And so we can actually just go straight into what our judge has filed. Here we have the judge's order setting status conference. First paragraph, he actually was going to continue to follow the same pattern pretty much throughout the entire case, I think, but we'll go through it just very briefly. The first paragraph, he identifies myself and what I filed, which is the motion to set procedure, my ex's opposition, and also the reply that I filed to her opposition. Next paragraph, he summarizes our current situation, which is that we share a common child and that we have joint legal and joint physical custody. And the next paragraph, he summarizes the motion that I filed and what I was requesting in that motion. Next paragraph, he cites he summarizes my ex's opposition and the requests that she, or I guess you could say the assertions that she raised in that opposition. And he also does mention that she is, bringing up that I didn't comply with WDCR 12, which is that rule that requires points and authorities to be included in all motions. However, as I mentioned in the opposition video, which is pretty sure was part 43, he just ignores it anyway. He's not going to really do anything about that. It doesn't mean that you should, do the same thing as I did. You should comply with all local rules. And I just wanted to go ahead and reiterate that I didn't comply with Rule 12 because I didn't know what Rule 12 was at the time. And I also didn't understand what the point of points and authorities was. I do eventually figure it out, but at this time, I still don't know. Scrolling down, we can see here that he summarizes my reply, and following that, he goes into his response, which is to state that this case appears to be ripe for a hearing, review hearing specifically, and he orders me to, within 10 days of the date of this order, send a notice to set to my ex and select a date and time. I want to mention something about this. I wonder if he did this, I don't want to say hoping because that sounds really bad, but non-attorneys don't really know what any of this stuff is. I didn't know what a notice to set was at the time. I looked it up and I found out what it was. It's actually defined in the local rules, in the 2nd Judicial District Court rules. And the way that it works is a little odd when you don't know what's going on with the court system. But in hindsight, it actually makes a lot of sense, and I actually like it. The notice to set is a process. I think I mentioned this, but I discuss it in detail in a video, and that video is called Notice to Set. But the way the process works is you prepare a document, it's like a one-pager typically, and you send it to your ex with a specific date and time. The specific dates and times that are available for choosing are defined in the local rules. You can't just pick any day you want and any time you want to do this. You have to check the local rules, at least in Nevada you do, and choose one of those available dates and times. Now, he mentions it in its order, which is nice, but if anyone ever goes through one of these cases and a judge doesn't mention this in their order, you'll have to check the local rules. And consistent with those rules, I have to pick a Tuesday, a Wednesday, or a Thursday. I can't pick a Monday or a Friday, that's not allowed. I have to pick one of those 3 days, and I have to choose a time within a specific window, which is from 9 to noon. I can't choose any time I want. If I do this, I am complying with the rules, and we'll be able to set a hearing on that date and time. I want to stress the importance of understanding this. That is not the day of the hearing. That is just the day that we all get together and choose the day of the hearing. A lot of times, this is done over the phone. There is hardly a point at all to show up in person and do this. You're not even going to see the judge. You're just going to see the administrative assistant. So you can pick this date and time, and then you can either personally show up to the judge's, chambers. I don't know how they do this in other states. There's a family desk, like a family counter that you had to go to, and they would go and get the administrative assistant, and he or she would come down to that floor and walk up to the counter and pull out this giant book, and they would go through it and find the best date and time that was available for the court. They would also typically call the attorney, but it is possible for the attorney to show up in person. It's just very inefficient for them, kind of a waste of their time and money for something so trivial. There's no reason why you can't do something so basic as this over the phone, and pretty much all attorneys do this over the phone. At least that's my understanding of it. Later on, towards, 2013, 2012, I started to just do it over the phone too. So anyway, you will confer with your opponent, and you will figure out a time that works for the court, that works for you, and that works for your opponent. And this includes witnesses. If you have witnesses that are going to appear, you'll want to consult with your witnesses to make sure that the date and time works for them as well. Once you set that date and time, then at that point the date and time that you're supposed to show up for the actual hearing. The last thing I want to mention is, if you don't show up to this, they won't set the hearing. If your opponent doesn't show up to this, they will allow you to set the hearing without their input, which I think did happen maybe one time in my case. And it's not a really big deal. A lot of attorneys will just check and see if the time that you chose was fine with them, and if not, they may try to continue it. It might irritate the court since they could have shown up at the notice to set, but these meetings are considered very low level on the scale of importance. So I just wanted to mention to my viewers that the setting process is a little bit lengthy, I guess, but it's not that complicated, and it does make sense when you think about it. When you've actually gone through it, it does make sense as to how it works and why it works that way. Other states do something known as calendar calls, and I think those are probably a lot less efficient, especially since it requires the attorney to appear at court. And I don't know, maybe other people have a different opinion about this, but I think that using this process is going to be cheaper and more affordable to, the clients that are paying these attorneys. And there's not like they're taking testimony, or it's not like they're looking at evidence or anything like that. And so it doesn't really seem to me to really require going all that way and going in front of the court just to go over something like this. So let's continue on down. And this is the typical boilerplate paragraph that's included in all court orders in Nevada that have to do with custody of a child. This is required by statute to be included in the order, even though it may not be relevant to what's going on at the time. And we've got the next paragraph, which discusses the international child abduction stuff. Same thing as prior. Here we have the certificate of mailing, where the court's administrative assistant is indicating that he or she mailed this order to both myself and my ex. Here we have the notice to set that I filed. In this notice to set, I am indicating, let's take a look here, that I have consulted with my ex's attorney, and that we are going to be meeting on the 20th of January 2009 at 11 a.m. to set a review hearing. It says here that she is to appear telephonically. I must have talked to her over the phone or something, and she said that she would appear telephonically, so I wrote it in by hand. I don't know why, but it's not like you have to specifically designate that. They can just, appear telephonically. Affirmation here, which is just indicating that the notice to set doesn't have a social security number. It's just this one-page document. Here we have the certificate of service, and This is indicating that I served my ex's attorney personally by taking that notice to set to her offices and handing it to the person who worked behind the counter. We've got the, I wonder, okay, there was one occasion where my ex's attorney wanted to talk to me, and I'm pretty sure this was when it happened. I went to serve the notice to set, and if it wasn't this precise document, it was very close around this period of time. It could have been a few weeks prior, maybe a week after, but there was a point, and I think this was it, where the staff member took the notice to set, or whatever document that it was that I took in, and asked me if I wanted to, well, didn't really ask me, just kind of let me know, hey, Ms. Bernie wants to talk to you. So I agreed, went back to her office, sat down face to face over her desk, and we talked about this particular dispute. And it wasn't necessarily not constructive, but I think that because I was so emotional, she didn't really extend this opportunity to me at any other time in the case. We were still able to communicate over email and occasionally by phone, and we were still able to get a lot done over email and by phone. But I really wish I would have handled that meeting differently. And it's very understandable for a person who's representing themselves to see their ex's attorney as sort of the catalyst to everything that is happening to them. And in a weird way, that's true, because if they were to lose their attorney, now they really wouldn't be able to function in the court system. A lot of people can't, or don't even have the idea that they can do this on their own. And I guess that's sort of the instinct that many of us have. But after a long time, after years of going through this, I did sort of start to realize how it wasn't really my ex's attorney. It was just my ex. She was pulling all the strings. She was in charge of all of this. And the attorney was just a person that she hired that would just go along with it. And it's easy to say, oh, well, they shouldn't do that. But when it comes to high conflict access like this, if an attorney tells them no, all they do is just go find another one. It's not like they just give up. Some people have cases where their ex has gone through like 14 different attorneys. They don't just give up when their attorney says no to them. They just find another one. So that's sort of the practical reason as to why it doesn't make sense. But then there's also this sort of ideological reason, which is that everyone has a right to an attorney, and to see this whole thing as being winnable by manipulating or getting rid of their attorney, it's a really messed up approach to solving this problem. Everyone really has a right to approach the court and to have legal representation. And so I try to get my viewers to shift away from attacking the attorney, because in the end, you're going to have to prove your case in court. And that's really what you should be focused on. But at the time that I met with her attorney, that wasn't my approach at all. I had this idea that I just needed to convince this person to, take my side. And if they would just take my side, everything would work out. And it's just completely not realistic at all with how attorneys interact with people, parties. And it's just the chance of something like that happening is 0%. They will not do that ever. And if they were to take your side, they would never tell you to your face and literally take your side. It would be more so something like they would tell their client that things just aren't working out and they need to get off the case. It would never be something like, yeah, you're wrong and I disagree with you and I hope your ex wins, haha, bye. That's just not how it works at all. So I think this is when this happened, and I just wanted to let my viewers know that you should not try to take that approach. You should instead try to, get into your attorney's shoes. And if you're going to discuss anything with them face to face, you should discuss the case, the pros and cons, the facts that are being alleged, the legal arguments that are being asserted, and look at it that way, and not make it just all about you and your kid, because they have a client and that client has the same kid and they can't represent you. You're the opponent. So if you're going to confer with an attorney, act as close to an attorney as you possibly can, because that's going to be the purpose of that meeting. I guess there are some attorneys that do this to manipulate or frustrate their opponent when they're not represented. I guess that's just part of their win at all cost mentality, if that happens to be the case. You could watch the video Win at All Costs if you want to get more into what I'm talking about there. And I do have a video on communicating with attorneys, and I can't remember what the title is, but try and track that down because I have some good advice in that video. I'm going to move on to the next document. Here we have the application for setting. This is a document that's prepared at the time of the setting by the court's administrative assistant. And it's just indicating the date that they conferred with both of us. And here it's indicating that they talked to me, they talked to my ex's attorney. We didn't demand a jury, which we really can't. And right down there at the bottom, they've got my signature because I was there in person. And then they just wrote down by hand, Catherine Burning by phone, which is typical. Typically what attorneys do is they just appear by phone on these. Going into the aftermath, I filed 2 documents, so I incurred $0 in costs. My ex's attorney filed nothing, and she incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably put 5 minutes into reviewing that order. It was just a very basic order that just said, hey, we're going to be setting a hearing. The other document, notice to set, I'll go ahead and put 5 minutes into that as well. Not because the document itself took her all that much time, but because we had a phone consult prior to actually choosing a date and time that she'd be able to appear by telephone. So we're looking at 10 minutes so far. The certificate of service is negligible, maybe a minute. The application for setting, I guess we could make that 4 minutes just to round it out to 5. 5 more anyway, which will bring it to 15 minutes. And the reason for that is because she would have had to actually spend a few minutes over the phone with myself and the administrative assistant of the department to actually pick the date of the hearing itself. Total of 15 minutes, which is going to come to $62.50 in attorney fees for my ex. And as with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.